Federal prosecutors walked into a courtroom in St. Paul, Minnesota with a stack of arrest warrants they expected to be a formality. Federal magistrate judges approve warrants like this almost automatically. The probable cause bar at this stage is one of the lowest in criminal law. It's not supposed to be a fight. It became one anyway. The judge picked up a pen, read through the charges line by line, and started crossing them out. On the warrant for one defendant, he wrote 2 words in the margin, by hand, "No probable cause." Days later, when the same Justice Department team came back asking him to sign off on a criminal complaint against a former CNN anchor, he refused to sign that one at all. Legal analysts called it exceptional. Magistrate judges reject federal complaints at this stage so rarely that CBS News' justice correspondent flagged it as newsworthy on its own. This wasn't a trial. This wasn't even a full hearing on guilt or innocence. This was the most basic gatekeeping function a judge performs, and the Justice Department couldn't clear it twice in the same case in the same week. What happened inside that courtroom didn't stay inside that courtroom. It set off an appeal to a chief judge, then an emergency request to a federal appeals court, then an arrest carried out anyway, in a different state, through a different process, days after a judge had already said no. The Attorney General's response? She said the Justice Department would pursue this to the ends of the earth. So the real story isn't just what a magistrate judge in Minnesota decided in January. It's what happens when a decision like that runs straight into a Justice Department that doesn't accept no as a final answer. Here's the headline, stated plainly. In late January 2026, U.S. Magistrate Judge Douglas Micko, presiding in the District of Minnesota, rejected a FACE Act charge against 2 defendants, civil rights attorney Nekima Levy-Armstrong and St. Paul School Board member Chantal Allen, for lack of probable cause, physically crossing the charge off their arrest warrants. Days later, Micko went further. When federal prosecutors sought a criminal complaint against former CNN anchor Don Lemon tied to the same protest, Micko refused to sign it at all, declining to authorize charges against a sitting journalist over insufficient evidence. The Justice Department escalated immediately. It asked Minnesota's Chief U.S. District Judge Patrick Schiltz to review Micko's decision. When that review didn't move fast enough for DOJ's timeline, prosecutors went further still, asking a federal appeals court to force the lower court to sign the warrants outright. The appeals court declined. None of that stopped the Justice Department from pursuing Lemon. Days after Micko's refusal, Lemon was arrested anyway, this time in Los Angeles, through a separate charging process. This is a story about what happens after a judge says no, and how far a federal prosecution can travel around that no before anyone forces it to stop. To understand why that no mattered so much, you need to understand what actually happened at that church in St. Paul and why the Justice Department wanted these arrests in the first place. If you're new to this story, here's the ground floor. On January 18, 2026, a group of protesters entered City's Church in St. Paul, Minnesota, during a Sunday worship service. The protest was aimed at one of the church's pastors, who reportedly served as the acting field director for the St. Paul 1CE field office. The protesters' target was the church's connection to immigration enforcement, not the congregation itself. The demonstration was live-streamed, including on Don Lemon's own YouTube channel, where he says he was present in his capacity as a journalist covering the event. The Justice Department's response came fast. Attorney General Pam Bondi announced arrests of 3 people: Nekima Levy-Armstrong, a prominent civil rights attorney and former Minneapolis NAACP chapter president; Chantal Louisa Allen, an elected St. Paul School Board member; and activist William Kelly. All 3 were charged under a civil rights conspiracy statute, plus, initially, a charge under the FACE Act, the Freedom of Access to Clinic Entrances Act, a law originally written to protect reproductive health clinics from obstruction, but which also contains provisions covering houses of worship. Here's what made this different from a routine protest arrest case. The Justice Department didn't send local career prosecutors to handle it. It sent 2 attorneys from the Civil Rights Division in Washington, D.C., a signal, according to a source familiar with the matter who spoke to CBS News, that career prosecutors in Minnesota's own U.S. Attorney's Office had real concerns about the strength of the evidence. And Don Lemon wasn't a bystander to Trump world's attention. President Trump himself had publicly called for Lemon's arrest before any charges were filed. So walking into that courtroom, you already had unusual ingredients: a civil rights era statute repurposed for a church protest, out-of-state prosecutors handling the case instead of locals, and a president who'd already said in public that he wanted one of the defendants arrested. That's the environment Judge Micko was reviewing charges inside of, and it's why what he did next carried more weight than a routine warrant review. Here's how the legal fight escalated, beat by beat. January 18th. The protest at City's Church takes place during Sunday service. It's live-streamed by participants, including Lemon. January 22nd. Armstrong, Allen, and Kelly appear in federal court in St. Paul for their initial hearing. Before the hearing even properly starts, federal prosecutors admit they haven't yet provided copies of the arrest warrants to the defendants or their attorneys. Judge Micko orders a recess and says he won't proceed until that's fixed, drawing audible gasps and cheers from the courtroom's overflow rooms. Same hearing. When proceedings resume, Micko denies the government's request to detain Armstrong and Allen and denies their request for a formal detention hearing. Civil Rights Division attorney Robert Keenan argues the case involves crimes of violence. Micko pushes back directly, telling him he doesn't see any threat or use of force in the record. Micko approves only one civil rights charge against each defendant, conspiracy against constitutional rights, and crosses out the FACE Act charge on each warrant, writing "no probable cause" by hand in the margin. That same week, the Justice Department seeks a criminal complaint against Don Lemon over the same protest. Micko refuses to sign it, a decision so unusual for this stage of a case that it draws national coverage. Within days, the Justice Department escalates the fight. It asks Minnesota's Chief U.S. District Judge Patrick Schiltz to review Micko's decision. When DOJ feels that review isn't moving fast enough, it goes further, filing an emergency request with a federal appeals court, asking it to compel the lower court to sign the arrest warrants directly. The appeals court declines. In his own review of the case, Chief Judge Schiltz doesn't just decline to overrule Micko. He goes further, writing that there is no evidence the journalists engaged in any criminal behavior or conspired to do so. January 30th. Despite the magistrate's refusal to sign a complaint against him, Don Lemon is arrested, not in Minnesota, but in Los Angeles, through a separate process. He's scheduled to appear in federal court there the same day. Meanwhile, a review of the federal docket reveals at least 8 sealed arrest warrants tied to this case, even though only 3 arrests had been publicly announced at that point, raising the question of how many other proposed charges Micko may have quietly declined. That's the arc, a judge saying no, twice, followed by a Justice Department that treated no as a starting point for the next move, rather than an ending point. What Micko actually said on the record is where this story hits its sharpest edge. Here's the contrast at the center of this case. And it's not spin, it's 2 competing accounts of the same set of facts, both on the record. The Justice Department's case, laid out in an FBI affidavit supporting the arrest warrants, describes a coordinated disruption, approximately 30 to 40 protesters working together in a coordinated manner entering the church during service. The affidavit includes witness accounts of parishioners being blocked from retrieving their children from childcare downstairs, of protesters confronting congregants with hostile language, and of at least one parishioner expressing fear that demonstrators might be armed. This is the government's factual foundation for arguing the protest crossed from protected speech into criminal obstruction and intimidation. Now here's the other side of that same set of facts, as reviewed independently by 2 federal judges. Judge Micko, reviewing the initial charges, told prosecutors directly in court that he didn't see any threat or use of force in the evidence in front of him. This in direct response to a Civil Rights Division attorney's argument that the case involved crimes of violence. That's not Micko rejecting the government's legal theory in the abstract. That's a judge looking at the same affidavit DOJ built its case on and concluding the violence and threat elements simply weren't there. Then Chief Judge Schiltz's review goes further. In his own written assessment of the case against the journalists specifically, Schiltz stated plainly that there is no evidence they engaged in any criminal behavior or conspired to do so. That's not a procedural technicality. That's the second highest ranking judge in Minnesota's federal court system looking at DOJ's evidence against journalists covering the protest and finding nothing there. And there's a physical piece of evidence in this case that's rare to see directly. A copy of the arrest warrant against Chantal Allen, obtained by CBS News, shows the FACE Act charge physically crossed out by hand, with no probable cause written in the margin. That's not a summary of a ruling. That's the actual document, a judge's handwriting in real time, rejecting a federal charge. Here's why the contrast matters so much. Probable cause is supposed to be the lowest bar in the entire criminal justice system. It doesn't require proof of guilt. It doesn't even require a strong case. It requires a reasonable basis to believe a crime probably occurred. Federal prosecutor Gene Rossi, a former DOJ attorney with no stake in this case, put it plainly when asked about it. When a federal prosecutor charges someone criminally, the department needs a seasoned, sage, and experienced prosecutor to vet that process. Because, as he said, when politics enters that process, bad things happen. That's the tension sitting underneath every part of this story. A Justice Department that sent Washington-based Civil Rights Division attorneys instead of local career prosecutors, pursuing charges against a former NAACP chapter leader, a sitting school board member, and a journalist, and two separate federal judges, appointed decades apart, independently concluding the evidence didn't clear even the lowest bar the system has. That's not one side spinning a story. That's the actual paper trail, an affidavit on one side, a judge's handwritten rejection, and a chief judge's written finding of no evidence on the other. And instead of accepting that outcome, the Justice Department did something unusual next. Here's where the story stops being about one courtroom decision and starts being about how far a prosecution can travel around a judge who said no. When Micko refused to sign the complaint against Lemon, the Justice Department didn't simply accept the ruling and move on to build a stronger case. It escalated immediately. First to Minnesota's Chief Judge Schiltz, then, when that review didn't move on DOJ's preferred timeline, to a federal appeals court, asking it to force the lower court to sign warrants it had already declined to sign. The appeals court said no. That's two separate judicial bodies in the same week independently declining to authorize the same charges DOJ wanted. And then, days later, Don Lemon was arrested anyway. Not through the Minnesota complaint Micko refused to sign, through a separate process in Los Angeles. According to reporting, federal agents came for him overnight. Lemon later told reporters outside the courthouse, "Last night, the DOJ sent a team of federal agents to arrest me in the middle of the night for something that I've been doing for the last 30 years, and that is covering the news." Harmeet Dillon, a senior DOJ official involved in the case, made the department's posture explicit, telling media the DOJ was still working on bringing Don Lemon to justice, and that prosecutors would pursue this to the ends of the earth. She said a review of Lemon's own protest footage gave DOJ what it believed were sufficient legal predicates to proceed under both the FACE Act and conspiracy statutes, directly contradicting what both Micko and Schiltz had already found in their independent reviews of essentially the same underlying evidence. There's one more layer that complicates the judicial independence held the line version of this story, and it deserves to be said plainly rather than glossed over. Micko's own ruling faced scrutiny over a potential conflict of interest. Reporting identified that Micko's wife works as an assistant attorney general in Minnesota, AG Keith Ellison's office, and Ellison has been a public critic of DOJ's use of the FACE Act in this case. Micko's chambers didn't dispute the relationship when asked, though a spokesperson said the court doesn't comment on judges' personal lives. That doesn't undo what the documents show. Schiltz's independent no evidence finding came from a different judge entirely, with no such connection. But it does mean this isn't a clean, uncomplicated story of a lone hero judge stopping an overreaching prosecution. It's a messier, more contested fight, with real questions on both sides, which is exactly why the Justice Department's actual position deserves a fair hearing before we go further. It's worth taking DOJ's actual argument seriously because the Steelman version is more substantive than they're just targeting a journalist for political reasons. The Justice Department's position, as laid out by Harmeet Dillon, is that federal prosecutors reviewed Lemon's own live-streamed footage from the protest and concluded there was a legitimate legal basis to proceed, not despite the video evidence, but because of it. That's a meaningfully different claim than proceeding on secondhand accounts. DOJ is arguing the defendant's own recordings support the charges. The underlying FBI affidavit also describes real, specific safety concerns that shouldn't be waved away. parishioners reportedly unable to reach their children in a downstairs childcare area during the protest, and witnesses expressing genuine fear during the disruption of a worship service. If those specific factual claims hold up, they represent legitimate law enforcement interests. Protecting worshipers' ability to safely attend religious services is precisely the kind of interest the FACE Act's church-related provisions were designed to address, even though the statute was originally built around clinic access. DOJ can also fairly point out that a magistrate judge's refusal to sign a single complaint at the earliest stage of a case is not a final adjudication of innocence. It's a preliminary screening decision, and the investigation remains legally open. Prosecutors retain the ability to present the same evidence to a grand jury, a different body operating under a different process, and Dillon has publicly said DOJ intends to continue pursuing charges through exactly that route. That's a legitimate, lawful path available to prosecutors when a magistrate declines a complaint. It is not, by itself, evidence of bad faith. It's also fair to note that not every judge who reviewed related aspects of this case sided uniformly against DOJ. Armstrong and Allen were still charged and prosecuted on the conspiracy count. Micko did approve, meaning the case wasn't thrown out wholesale. It was narrowed, not eliminated. None of this erases what two federal judges independently found when they looked directly at DOJ's evidence: the no threat or use of force finding, and Schiltz's no evidence conclusion are matters of record, not opinion. But the honest framing is that DOJ believes it has a case it can still make through a different legal avenue and has said so on the record rather than quietly dropping the matter. Whether a grand jury reaches a different conclusion than two magistrate and district judges already did is a real, unresolved question, not a foregone conclusion in either direction. Here's why this case is bigger than one journalist, one protest, or one Minnesota courtroom. The entire structure of federal criminal law rests on the assumption that the probable cause check at the front end of a case is a real, functioning safeguard, not a rubber stamp. Magistrate judges approve the overwhelming majority of warrants and complaints presented to them. That's normal and, in most cases, appropriate. What makes this story worth your attention isn't that the system worked exactly as designed once. It's what happened when it did. When a judge said no, the response wasn't to build a stronger case and come back. It was to escalate. First through a chief judge, then through an emergency appeal to a federal appeals court, and then, when neither of those worked, through an entirely separate arrest in a different state. That pattern is worth sitting with regardless of what you think of the underlying protest or the politics involved. It's a live example of how much room a prosecution has to maneuver around a no, and how many separate legal doors exist for a determined Justice Department to keep trying. That matters to you directly if you've ever assumed that a judge's rejection of charges means a matter is settled. In this case, it didn't. The investigation stayed open. The arrest happened anyway through a different channel. And the next legal move, a possible grand jury indictment, is a process that operates almost entirely outside public view, with none of the adversarial testing that happened in Micko's courtroom. Whether you see this as prosecutorial overreach or as legitimate persistence in a serious investigation, the mechanics are the same either way, and they're mechanics that exist for every American, not just the people named in this case. A probable cause rejection at a magistrate hearing is one checkpoint. It is not the finish line. If you're trying to understand how much protection a not enough evidence ruling actually buys someone in the federal system, this case is a live, ongoing answer, and it isn't finished yet. So where does this actually stand right now? The investigation into Don Lemon remains officially open. Dillon has stated publicly that DOJ can still pursue a grand jury indictment, a process that doesn't require a magistrate judge's sign-off the way a criminal complaint does, and that operates under grand jury secrecy rules, meaning the next move here could happen with almost no public visibility until charges are either returned or the matter quietly closes. Lemon himself seemed to expect exactly this. Before any of the appeals played out, he predicted on his own podcast that the Justice Department would probably try again. His attorney, Abby Lowell, has said Lemon would fight any charges vigorously and thoroughly in court if DOJ continues what Lowell called its attack on the rule of law. Meanwhile, Armstrong and Allen's cases haven't disappeared either. They're still facing the conspiracy charge Micko did approve, moving forward on a separate track from whatever DOJ decides to do with Lemon. And that detail about at least 8 sealed warrants on the docket against only 3 publicly known arrests means there may be additional charging decisions, approved or rejected, that haven't become public yet. Here's the actual open question hanging over this entire case. Does a grand jury, operating with none of the adversarial pushback that happened in Micko's courtroom, reach a different conclusion than 2 federal judges already did when they looked directly at DOJ's evidence? Or does the same evidence that failed to clear the lowest bar in the federal system twice in front of 2 different judges fail again in front of different eyes? We don't know yet. That's exactly why this isn't a closed story. It's a story with its next chapter still being written, likely without much public notice until it either produces an indictment or quietly ends. If you want to know the moment this moves, whether that's a grand jury indictment, a dismissal, or another twist in how this Justice Department pursues cases after a judge says no, that's exactly the kind of follow-through this channel is built for. Subscribe and turn on notifications so you're not finding out 3 weeks late from a headline that's already missing half the context you just got here.